Most founders don't lose patent opportunities because someone stole their idea. They lose them because they make a few completely normal decisions, but too early, and those decisions quietly reduce what they can protect later. Because patent mistakes usually don't feel like mistakes in the moment. But if you're not careful, those early moves can shrink your options before you even understand what was valuable. I'm Rich Goldstein, patent attorney, and if you're building something differentiated, this is not just a legal issue, it's a strategy issue. So let's get into it. The first mistake is talking about the invention too early. And I don't just mean announcing that your company exists. I mean revealing how the thing works, what makes it different, what the special mechanism is, what the process is, what the system is, and what your secret sauce actually is. This is where founders get tripped up because they think, I'm just pitching, or I'm explaining it on a podcast, or I'm sharing it with investors. But from a patent perspective, timing matters. And once you start disclosing key details publicly, you may be creating problems you can't fully undo, especially if international protection matters to you. Here's the smarter way to think about it. A patent's not about proving you had an idea. It's about protecting a specific invention in a specific way. The question is, did I reveal the part that might have been protectable before I even had a filing strategy? That's the distinction clever founders understand. Not all exposure is equal. Some exposure is branding, some exposure is product education, and some exposure quietly burns future patent options. Mistake 2. The second mistake is waiting too long because the product is not ready yet. This one sounds reasonable. That's why it's dangerous. Founders will say, we're still iterating. We want to wait until version 2. We'll deal with patents later after launch. We're still figuring out the final build. But patent strategy is not only for finished products. In fact, one of the biggest founder blind spots is assuming that protection starts when the product is polished. And it often needs to start much earlier than that. Because what may be protectable is not just the final packaging. It may be the method, the system, the architecture, the workflow, the technical approach, or the way the problem got solved. And if you wait till everything's fully baked, sometimes what happens is this. You launch, you start talking, you start selling, you start exposing the value, and only then do you ask whether anything should be patented. That's backwards. The clever mindset is this. Don't wait for perfection. Identify value early. You don't need to know every future feature. You don't need to start recognizing when you may have created something strategically worth protecting. The third mistake is assuming that the company clearly owns the invention just because the company paid for the work to be done. This is a big one. A contractor helped build the product, a technical advisor shaped the core functionality, a co-founder came up with a part of the inventive concept before the company was fully set up, or an outside developer contributed something important, and the founder assumes it's ours, we paid for it. Not necessarily. This is where patent strategy overlaps with ownership reality, because it's one thing to have something innovative, but it's another thing to have clear rights to it. And smart founders understand that value is not just about what was created. It's about whether ownership is clear, documented, and usable later in due diligence, fundraising, or acquisition. This is one of those mistakes that often stays invisible until it becomes expensive, because nobody notices while the business is small. Then later, an investor, a buyer, or a lawyer asks some basic questions. And suddenly, something that felt quite simple becomes messy. The clever takeaway here is this. Innovation that occurs without clear ownership is much weaker than founders think it is. If you're building something differentiated and you're already talking about it, already launching it, or already building it with outside help, this is the right time to get clarity on what's still protectable and what steps you should take next. And if that's where you really are, then reach out, because blind spots about what you don't know and about the questions you don't know to ask. And the earlier you see those blind spots, the more options you usually have.